The preamble to the Bill of Rights. Congress of the United States begun and held at the city of New York on Wednesday, the 4th of March, in the year of our Lord, 1789, the convention of a number of states, having at the time of their adopting the Constitution expressed a desire in order to prevent the misconstruction or abuse of its powers, that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent ends of its institution. Resolved by the Senate and House of Representatives of the United States of America in Congress assembled, 2/3 of both houses concurring, that the following articles be proposed to the legislature of the several states as amended to the Constitution of the United States, all or any of which articles, when ratified by 3/4 of said legislators, to be valid to all intents and purposes as part of the said Constitution. Articles in addition to and amendments of the Constitution of the United States of America proposed by Congress and ratified by the legislature of the several states pursuant to the 5th article of the original Constitution. Courts are to interpret the people's vested rights in the understanding of the common law. Unalienable rights are the ruler that limits all statutes and all court decisions. If they don't measure up, they are null and void. Congress shall make no law, all right, that affects man. Congress does not make law for man. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for a redress of grievance. For government servants to designate areas called free speech zones are absurd and must be disobeyed. For courts and the judiciary to tell you that you're not allowed to record in a public building is absurd and wholly void, ladies and gentlemen. Let me tell you something. I had a very articulate conversation with a judge one time, and I said, here's the deal there, Scooter. You telling me I can't record in here, there's only 2 types of people in this world that I know don't like being recorded. Criminals and a porn star after a long, hot, sweaty day of work. And you, sir, do not look like a porn star, all right? So, we look at the latter and figure you're more or less a criminal, right? Amendment 2. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, only an educated idiot would argue about what the word infringe means, okay? But a 2-year-old knows what infringe means, okay? But you have these lawyers that perpetuate that that's not really the intent of the founding fathers. It was not left to interpretation, ladies and gentlemen. The word infringe is clear as a fucking piece of crystal glass, all right? Comment. Militia Act of 1792, passed May 8th, 1792, provided for the organization of the state militia. It conscripted every free, able-bodied male citizen between the ages of 18 and 45 into a local militia company. New York State Constitution, Article 7, Section 1. The defense and protection of the state and of the United States is an obligation of all persons within the state. Therefore, it is clear that it is the right of the people to own arms, and nothing is to infringe upon that. Licensing a right is an infringement. Running a background check before selling a firearm is not, okay? Because a firearm is federally defined by the federal government, okay? Which applies again to government, yet again, or the volunteers who participate in that racket. So, But background checks are infringements if one must wait for the result before being able to get his firearm. Again, I don't like the word firearm. It wasn't in the Constitution as firearm. Back in the day when they created this provision within the Constitution that shall not be infringed, people in Kentucky and Tennessee had cannons in their front yard, ladies and gentlemen. The force that they carried was of the same magnitude and weight of the United States and its government. Amendment 3. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in the manner to be prescribed by law. Amendment 4. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. According to Black's Law Dictionary, the word oath, in its broadest sense, includes all forms of attestation by which a party signifies that he or she is bound in conscience by a solemn and formal declaration or asseveration that an affidavit is true. No warrant, including federal warrants, are to be served without going through the sheriff's office. Any warrant without a sworn affidavit and a judge's wedding signature, not a stamp, is not an executable warrant. It is the sheriff's duty to make sure that all warrants, federal or state, served within their county passes constitutional scrutiny. IRS warrants rarely pass constitutional scrutiny. For example, the IRS has a Form 4490 called Proof of Claim for Internal Revenue Tax, which is an affidavit form that must be filled out, or sworn to, without which the warrant with the wet ink signature is not executable. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. No one can be sentenced to jail without first having due process, which means being indicted and tried by a jury, 12 jurists, and not trial by judge or tainted jury. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. This so often in state courts nowadays is not articulated, the nature and the cause. They will always tell you what the cause is. They will never tell you what the nature is, because in admiralty, it's always about commerce. CFR 277211, all crimes are commercial. Rape, sodomy, murder, the list just goes on and on and on. It doesn't matter. Theft, they're all commercial and admiralty, okay? So they'll always tell you what the cause is. They'll never give you the true nature. Also, to expand upon warrants, what they're doing nowadays is known as a capias. It doesn't actually qualify as a warrant. It is in the commercial venue. The warrant that they're issuing with a form of a capias is actually a paycheck. Accept it for value, endorse it, give it back to them. They have no reason to hold your body. Plus, if they're holding your body, they are to take you to the nearest magistrate immediately. Don't let these clowns tell you that they're not going to wake up the judge at 3 a.m. They're violating your unalienable rights if they refuse to do so and put you in a cage. Absent an actual crime, which means they either witnessed you cause harm, damage, and loss to somebody, physically assaulting them or trespassing on their rights, and there's 2 viable witnesses that are going to make oath to that fact or make an asseveration or a statement of fact, structured as an affidavit to support it. If they don't have those things, there's only a couple of reasons that you can actually be arrested without a warrant. And one is disturbing the peace, okay? And we'll talk about that a little bit later. Murder, obviously, is an arrestable offense. They can arrest you immediately. They can put you in a cage. But you are to be brought before a judge, and then the moving parties are to come forward simultaneously while everybody is there, and you guys are supposed to articulate the facts, and the judge is supposed to make, as a referee, the decision of whether or not there exists probable cause, okay, of a crime that has been committed. And it's really not a crime. It would be more of a common law tort or trespass by a wrongdoer who has caused you harm by violating your rights, would grant rise to be incarcerated. So we'll move forward. To be confronted with the witnesses against him. Now, I've had a lot of people argue with me. Well, Derek, you always say that you have the right to face your accuser. Well, let me ask you something. Is a man with firsthand knowledge as a witness that you trespass against him, does he qualify as an accuser? Does he also qualify as a witness? Yes, he does. Is the state of Nebraska, state of Colorado, state of Arizona, state of Texas coming forward? No, they are not. This is all color of law. They're violating your rights under the color of law, presuming and assuming that you're subject to some benign statute, code, city ordinance, rule, or regulation that quite frankly does not apply to you. It applies to them, okay? And so we're moving forward here. To have a compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel, not a lawyer, not an attorney. The very definition for the word attorney is to return property from one person and give it to another, okay? That's an attorney. Nowhere in the Constitution, the Federalist Papers, the Magna Carta, any of that does it say that you have a right to an attorney. It says you have a right to counsel, a man learned in the law, okay? Have the assistance of counsel, and by denying you your counsel because they're not a bar member constitutes a denial of due process of law. It's one of those rights that we call a substantive right for his defense. All criminal trials must be by an untainted, well-informed jury. It does not say assistance of bar attorney. It says counsel, which can be anyone the accused feels best advise them. Amendment number 7. In suits at the common law where the value is a value in controversy shall exceed $20, the right of trial by jury, notice how it says trial by jury, not jury trial, trial by jury, shall be preserved. These words are so important, people. So often it gets misconstrued. Oh yeah, I had a jury trial, and it was fair, and I understand everything that happened on. I'm telling you right now, by using the word jury trial, you have no idea what you were doing. You were bamboozled. You were brought into a federal territory, an Admiralty Article 1, Section 8 court, okay? And you did not have due process of law. And another way to evaluate that is when you do a trial by jury, there is no reversing what the decision that has been made by a trial by jury. Whereas a jury trial, you can go back and challenge at a later date, okay? But a trial by jury, you cannot. Once that verdict has been ruled and rendered, it is done. It is finished. And there are many Supreme Court cases that support that as well. Shall be preserved. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. All jury trials are trial by way of juries are common law trials, aka courts of record, okay? And the Admiralty Court, they'll tell you, oh, we're recording it. It's being recorded. That's not what I asked. I asked if this was a court of record. I want to know who's got standing in this room. Where is the real interested party moving this case, ladies and gentlemen? If it doesn't exist, this case should be dismissed immediately for want of prosecution, okay? Pay attention to what I'm saying. I'm very well versed in this shit. Amendment number 8. Excessive bail and bond shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. ladies and gentlemen, when they're holding you against your will, and let's say the officer says, well, we have the ability to hold you for 72 hours. That's a bunch of cockamamie horse shit, okay? Because by the law of the land, you are to be brought to the nearest judge, and you are to have the right to explain yourself, and they have to bring forward the witnesses or the man or woman you caused harm, damage, loss to come forward and point directly at you and say, this is the wrongdoer, this is what he did, this is why, he should be arraigned for court. We need to put this evidence before a grand jury or a petite jury and make sure that we can indict this man for what he has done, right? And part of due process of law is notice and opportunity. So this gives you opportunity to make right there on the spot. If they articulate that you are a wrongdoer, that you did something wrong, as an honorable man or woman, you should immediately about face to the right and look at them and say, I admit this is what happened. What can I do to provide remedy? Is there a way that I can provide remedy to you? That is absolutely what happened. It was an accident or whatever the case may be. But the facts still remain the same. I'm an honorable man. I was raised correctly, and it's abundantly clear that my actions caused you a loss of some sort, and I would like to provide remedy. All right. So once we remove that controversy, there's no need for court anymore. Once you settle it on the private side, it's done. The court has no jurisdiction at all. So that, again, leads to due process of law. Where was the proper notice and opportunity so that I could provide remedy on the private side before we came into the public arena with this, okay? Solitary confinement. And I dealt with solitary confinement. I call it solitary confinement. They now call it, in the prison system, I've been there a few times, it's very funny. What did they call it? Segregation. Okay. And this is where we start splitting hairs with political correctness. And I said, why have I been here for going on close to 14 days now in solitary confinement? He says, well, sir, let me be very, 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 very clear with you. You're not in solitary confinement. Solitary confinement has been rendered inhumane. And I go, okay, then where am I at? He says, you're in the new segregation unit. Oh, segregation. I said, okay. Can I ask you a question? He said, certainly. I said, have you changed the size of the cell? No. Have you made the windows bigger? No. Have you made the bed nicer? No. Is the shitter still attached to the sink? Yes. I said, is the door bigger? No. Have you changed the paint in the room? No. So you mean to tell me the only thing that has changed about solitary confinement versus the segregation unit is just the words you're using? Well, when you put it that way, yes, people, political correctness will fuck you over time and time again because it's solitary confinement, and solitary confinement has been ruled to be unconscionable. It's torture. Remember, we were talking earlier about the Eighth Amendment, cruel and unusual punishment. That classifies under the Eighth Amendment as cruel and unusual punishment, putting you in a single cell that was formerly solitary confinement, now considered the segregation unit. Okay, that's cruel and unusual punishment. Dieseling and refusal of medical needs are psychologically and physically destructive and are therefore cruel and unusual punishment. Okay, so it pays to be learned. It pays to become knowledgeable about this stuff. I had an incident with a sheriff in a county that didn't want to provide medical attention. He proclaimed that the injuries were sustained long before he had gained custody, and because of that, he had no obligation, and he wasn't going to do this or that. When shit hit the fan, he realized, well, this guy isn't so fucking stupid after all. So becoming learned will help you greatly, and that's why I do these videos. Moving on. Amendment 9. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, I hear a lot of people that talk about the Constitution. And they always say my constitutional rights. You don't have constitutional rights. You have constitutionally protected rights established by we the people who at that time understood the oppressive nature of monarchies and oligarchies and communism and so forth, okay? And so they thought it best to put it in plain text so that we would never lose what they had fought so hard for. And thus the Constitution is not open for interpretation. It says what it says in plain, verifiable English. It is not to be construed or interpreted in any other way than as it is written, period. Okay? And the Ninth Amendment is so important, yet so many people have never even gone as far to read the Ninth Amendment. We hear about the First Amendment. We hear about the Second Amendment. We never hear about the Third Amendment because nobody gives a shit about quartering armed forces, you know. But it's very, very important. When they kick in your door and come into your house and the castle doctrine is in effect, okay, they have essentially quartered themselves in your house without your permission. Castle doctrine is something everybody should go read as well. But the importance of all this is the Ninth Amendment. What has been written here is great foundational work. But it's not the end-all be-all, ladies and gentlemen, because the Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now remember, I told you, Congress doesn't make law for we the people, and the legislature doesn't make law for we the people, okay? We are governed by the common law. Okay, by sound doctrines and principles, what's right, just, and fair. Keep your hands and feet to yourself. Don't cause any harm. Don't start no shit. Guess what? There shouldn't be any shit. But we've been at war constantly for over 200 years with the alleged powers that be that are really empowered by we the people and our ignorance. Okay, they were first put in power by us to protect us and our rights. And now it's been flipped 180 degrees the other direction because we have slumbered upon our rights. We have allowed to fall away from the lessons that history so often taught us. And simultaneously, history has also shown us that when we forget about the past, we are doomed to repeat it. Okay? So remember, just because what's enumerated in the Constitution, that isn't the end all be all. There is much more beyond that so long as you can articulate your rights. I had a judge tell me one time, I'm going to read you your rights. And I started laughing like a little schoolgirl. I thought it was fucking hilarious. So he starts reading a few of these off, and I go, I'm just a little perplexed here, Judge. You're going to read my rights? This is going to take all fucking day. It could take up to 10 fucking years for you to do this. This is a daunting task. You know this, correct? I have the right to urinate, masticate, masturbate, defecate. I have the right to run, jump, swim, breathe, inhale, exhale, harvest food. I mean, we could be here a long time. Well, I'm just going to give you the basic ones. The basic? Well, who are you to dictate what is basic and what is not? Who are you to tell me what my rights are and what they are not? Are you practicing law from the bench? Are you my counsel? Are you my advisor? Are you the disinterested third party set the rule on the matter? I'm a bit confused here, dickhead. You see how that works? When you know your shit? Whoa. This is just part of the process. This is just what I have to do. Man, you don't have to read me my fucking rights, dude. I know my rights. Way beyond what you have written in front of you that was authorized by some fucking dickhead legislator, okay? Way beyond that. All right. The important thing is that you understand your rights and the troubles and the damages that you may cause by purportedly executing your oath of office in good faith, all while acting contrary to your oath of office. That maybe we should talk about that and make sure you understand that and the ramifications of not honoring your oath, breach of the peace, conspiring against my unalienable rights with shit dick over here who doesn't have a plaintiff, who doesn't have anybody coming forward making sworn pleadings, who doesn't have anybody that's independently bonded this motherfucking case. All right, maybe we should talk about that shit. Moving forward, 10th Amendment, another extremely important amendment nobody really talks about. Now, 1 through 10 is the Bill of fucking Rights, people. This is very, very important. Amendment 10. The power not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or the people. Well, what is the state? The state is the people collectively, right? So when they're saying the states respectfully, they're talking about the people. And just in case somebody wants to misconstrue the states respectfully, They further went on to explain the people, period. We have many unalienable rights not mentioned above, such as the right to travel without license, take medicine, or recreational drugs, deny courts not of record, carry firearms, etc. Again, I don't like the word firearm as it is a federally defined term and words have meaning and power in certain jurisdictions. So pay attention to that. I have the right to bear arms. And what you term as a firearm is technically my property. And I can call it an ugly black fucking duck if I want. And I have the right to my ugly black fucking duck. And there ain't a damn thing you can do about it. Period. End of fucking story. Take my property and I'll require just compensation and not at the current market value, whatever the fuck I say it's worth. Eat that shit. All right. So the consent of the governed that to secure these rights, governments are instituted amongst men deriving their just power from the consent of the governed. Declaration of Independence. Now, if I do not want or wish or desire to be governed by these monkeys out of the District of District of Columbia, I think I got it right the first time, but we better be pretty fucking specific here. I have a right to tell that form of government to fuck off, and you should too. But it may behoove you to have the knowledge to support telling these people to fuck off, and you can do it quite proper. Now, for those of you that believe the sheriff is acting in his official constitutional delegated authority, I can assure you he's not. And the first telltale sign is just go look at any sheriff vehicle out there and you will notice that sheriff is in all capital letters. Now, I can remember when I was younger, the word on the side of on the sheriff's vehicle was never in all capital letters, but nowadays it is. And that is a distinctive difference that I have noticed, okay, which tells you that they're operating under a DUNS number as a corporation for federal funding. And that's how they've been militarized. And they get fancy fucking fully automatic weapons and flak jackets and MRABs and all this other cool tactical defense tools. Am I opposed to the sheriff having stuff like that? No, not really. So long as he operates and abides by his oath. The sad thing about it is, I've spoken to many sheriffs throughout the nation, and I've asked them all this one very important question. How many of you have actually read the Constitution? And you know, a lot of them tell me, well, we touched this just a little bit on it in the academy, just a little bit, but you didn't read it? Because an oath means that you are committed for life. That oath is very serious. That's a life commitment to support, defend, and uphold that Constitution. That isn't a joke. That's the reality of it, okay? Gang members and whether it be motorcycle clubs or whatever else, they take their oath very fucking serious. And that's what makes them formidable, okay? But when we have sheriff's departments and police officers who take this oath, and military members furthermore that take this oath, but none of them have actually read the Constitution prior to taking that oath. That means they took their oath under false pretenses, ladies and gentlemen. They're unjustly enriching themselves under a false promise. That's honest services fraud. All right. So important to be able to be cognizant of the truth. All right. We the people consent to government by exercising the following 7 unalienable rights. 1, when we freely elect committeemen who choose the candidates who will be on the ballot. 2, when we cast out vote at the ballot box. Now, there's something in this literature that I don't agree with, because a voter is subject to the District of Criminals. Okay, and viewed as a volunteer employee, subject to statutes, codes, city ordinances, rules, regulations, and all that gobbledygook that these assholes create. Okay, but an elector is somebody who has power. Okay, an elector is someone who is protected by the state constitution, who is protected by the federal constitution. Okay, that keeps the check and balances in place. Voters are nothing more than mindless maniacs, but an elector is someone who holds property and has an interest, a vested interest in liberty and freedom, okay? Whereas a voter is nothing more than a glorified pom-pom queen on the sidelines cheering, rah, rah, shishkamba, fuck us all over and create some more bullshit legislation while you disregard our votes, a popularity contest, and you throw some schmuck in there whose son smokes crack and sells our country out. All right? That's the reality of it. If you can't see that fucking reality yet, I don't know what the fuck to tell you. There's a screw not quite right with you if that be the case. If you can't understand that your vote don't fucking matter, all it does is enslave you, you got a major fucking problem that needs to be reevaluated, okay? When we cast out vote at the ballot box. Number 3, when we exercise our right of recall. 4, when we exercise our right as grand jurists to indict or not. Now, there's another problem here. Yes, we have a right to a grand jury. Okay, we have a right to a petite jury. The problem is the juries have all been compromised by the Bar Association. Okay, they're operating in Article 1, Section 8, military tribunals. They're operating in their own private, for-profit, ad hoc corporation business. They're actually renting our courthouses to do this business in order to negotiate securities and bonds. That's what they're doing. Okay, 5. When we exercise our right as petite trial jurist to convict or not. 6, when we exercise our right of nullification. And 7, when we exercise our right of denying courts not of record. Okay, so in order to nullify a law, all right, first of all, you have to understand that if it was unconstitutional to begin with, it was void in absentia before some knucklehead or nut job even dreamed it up and put it on fucking paper. Just so you know. Before it was even scribed on paper, it was bullshit, it was null and void, and had no effect, even if it was passed. Doesn't matter, okay? But what the court system does now is the judge will instruct the jury that they are to make a decision based upon the facts, and the judge will tell them the law. That doesn't fucking say that in this Constitution, and it don't say that, and furthermore, in any of the 50 states' constitutions, ladies and gentlemen. Where did they get that fucking whack-a-mole idea? Well, they conjured that up because the American people fell asleep. They were lulled to sleep in the public fool system, and they're led to believe that these highly educated, prestigious people holding a title of nobility would never lie to them, and they absolutely know the law. They don't. They may know the law, and ignorance of the law doesn't excuse anybody, for everybody is responsible for knowing the contracts they enter into, including their fucking oaths of office, all right? And they're taking their income, so whether or not they took the oath of office or not, equity imputes an intention to fulfill an obligation, and we can still nail their nuts to the fucking wall, and we should. So I just wanted to expand upon that a little bit. When the judge is trying to tell the jury the law, he's way outside the scope of his fucking authority. He's practicing law, and now he's tampering with the jury. And that's a crime. That's a motherfucking crime his ass can go to Guantanamo fucking Bay for. All right? Don't ever let these cocksuckers try and tell your jury the fucking law. Nail his ass for it. When we exercise our right of denying courts not of record. By the aforesaid rights, we the people have total control and consent of government and the exercise of our liberties. Any infringement upon any of these unalienable rights is an act of war against the people and against the Constitution and against God, all right? That's a mixed war against the Constitution. The people are entitled to the laws of nature's God. Now, this was something that was articulated by Thomas Jefferson. Okay, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. That to secure these rights, government are instituted among men, deriving their just powers from the consent of the governed, that whenever that whenever any form of government become destructive of these ends, it is the right of the people to alter or abolish it, and to institute new government laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Declaration of Independence. Informed jurors. A common law court is one that carries out the will of a tribunal, aka a trial by way of jury, under the principles of the common law, and consistent of 1. A free, untainted, and fully informed jury. 2. A magistrate who administers, a referee, the will of the jury and not his own, meaning he's not practicing law from the bench saying he will explain the law, you guys will decide the facts. That's bullshit, and you call them on it, not some of the time, not part of the time, every fucking time. And if they got an issue with it, you just tell them Derek Gonzalez says fucking hello, all right? 3. A prosecutor who represents the people and not the government, and 4, a constitutional bailiff, aka sheriff deputy. Jurists and bailiffs must be under the people's control and not political control, okay? Now, I've had the bailiffs tell me, I don't work for you, I work for the judge. Ho, ho, ho! We got a problem, Scooter. Don't put that in fucking writing that you work for the judge, that you're violating the separation of powers clause, that you're willfully, knowingly, and intentionally violating your oath of office and absconding from your fucking duties, taking your income under false pretenses. Would you mind putting that on paper, Scooter? I'd love to have that, Barney motherfucking 5, you dumbass. All right? Now, when you hit them up with that, they're, of course, going to tell you, oh, I'm not going to put that on paper. That's why it's essential that we all have recording devices in the courtroom to catch these criminals red fucking handed, okay? So fucking important, because criminals so often don't want you to record. They don't want you to have your own stenographer in the courtroom. You want to see a different court? I'll tell you what. Hire a private stenographer to come in and sit in the fucking courtroom, and you watch how everything magically fucking changes, okay? Because now the judge doesn't have control over all the pissants in there violating their oaths of office. Now he's got somebody in there that's on your side that's actually creating an accurate fucking record that won't be altered, all right? And if you really want to get cute, you stack about 4 or 5 notaries in the room at the same time. It's a real shit show then. All right, because they don't have any wiggle room at that point. Their ass is strapped and bound to their fucking chair. They're screwed. All right. 4, a constitutional bailiff, aka sheriff's deputy, jurist, and bailiffs must be under the people's control and not political control. It is the duty of a jury administrator to fully inform jurists of the following. Jurists must act with a sense of honor. Jurists must act with a sense of justice. If justice find the defendant guilty, they must consider mercy. People have a right to see the grand jury without a monitor. Grand juries must consist of 25 people. Petite trial juries must consist of 12 people. Jurists must refuse to enforce unjust laws. Jurists cannot be required to ignore their conscience. Jurists cannot be punished for their verdict. This is so important. Whatever the verdict may be, no matter how mad the alleged administrator, aka judge, is, he cannot inflict any violence upon them. He cannot throw them in contempt of court, because he would be tampering with the jury. And that is a federal offense. And he can go to Guantanamo fucking Bay for tampering with the jury. All right. Now, I have read a couple court cases that blew my mind, where a judge didn't like the decision the jury came out with, and he sent them back into the jury room and said, now you come out here with something that this court can agree with. That son of a bitch should have been shot in the fucking head. He should have been taken outside. Nearest cowboy should have pulled up with his horse in a saddle and strung him up from the saddle horn of the horse, from the saddle, from the nearest fucking tree, from dawn till dusk, and let him fucking swing there so everybody knows you don't do that shit in this country. But unfortunately, people think, oh, Derek, that's just so fucking inhumane. What they're doing to you by trafficking you the way that they're trafficking you is inhumane. What they're doing to you by making false promising to uphold something they've never actually read themselves, is inhumane, okay? Taking your grandmother from her homestead and putting her in her nursing home to liquidate her assets, to be little lying, looting, pillaging plundering thieves is an atrocity. Okay, that should concern you enough to become learned in this. Jurists have the power of nullification. Jurists decide both facts and law. The judge doesn't get to decide that shit. He doesn't get to fucking to tell the jury what the law is. That's for the people to decide, to see if Congress or the legislator have stepped outside their bounds, or whether or not what Congress and the legislator create even apply to we the people. Jurists have the power of nullification. Jurists decide both facts and law. Jurists must restore and or compensate the injured party. With the exception of dangerous people, jail should be the last resort. The convicted must be able to pay restitution. If the jurists are concerned with the convicted escaping their punishment, their movements can be monitored electronically. There is no such thing as a hung jury. Jurists must remain in deliberation until they reach a verdict. Now, here's the thing about that. This part is wholly inaccurate. If even one juror decides a man is not guilty, okay, then he's not guilty, period. It's not a hung fucking jury. When a man is found guilty, he must be found guilty by all 12 jurists, period. All right? And that is a fact. That is the importance of a jury, that the jury must be provided instructions, and those instructions, if you're the purported defendant, which there's a number of reasons you can't be the defendant, because under Federal Rules of Civil Procedure 17, the defendant is in the capacity of an officer or someone holding office for the government, and most people that are in court aren't actually fulfilling that office, aren't getting paid for holding office, and are being dubiously duped into volunteering to hold some superficial office so they can act their Article 1, Section 8 court military tribunal against you, okay? So it's important to be cognizant of that as well. You need to know what jurisdiction and what venue you are in, which would lend to the nature and the cause, okay? Which would also say, I see no real party and interest in this case coming forward, making sworn testimony under the pains and penalties of perjury, independently bonding this case, and I believe none exists, which means that this case should be dismissed for want of prosecution, all right, before we ever even get to the jury side of things. If jurists are absolutely deadlocked, they must acquit. In order to convict, it must be a unanimous decision. Jurists are the king's bench and must do their best to exercise the will of the king, God himself, on the court. When we come back, we'll talk about only the people can file a criminal complaint. All right. Thanks for joining me, and we'll talk to you real soon.